I happen to have been a pilot in the Air Force years and years ago, and I kind of have this romantic attachment to flying. So I've spent a lot of time following, the things about aviation, and I've also, because I'm in environmental politics and policy, I have a science background, specifically in meteorology. So I understand meteorology. And I understand the nuances of meteorology. Well, this whistleblower that came to us was a service provider for a major company, a big company that had bought out the National Weather Service in providing weather briefings to pilots. And this was during the Bush administration, where the mantra was let's privatize everything. So the National Weather Service, which at the time had Monterey, there's a weather service in Monterey, and they had these regional centers. I don't maybe 30, 40, 50, 60, I don't a lot of them that would do this job, provide information to pilots. Pre-flight, during flight, you want to know you're flying from Houston, Texas, up to uh, Las Vegas. Well, that's a lot of different kinds of terrain, a lot of different kinds of weather. So you would, before this arrangement, you would call in to the appropriate weather, center and say, "I'm flying this route. Tell me what the weather."
This is critical information.
Absolutely critical. Absolutely critical. This is probably the most critical information in flight that you get. And particularly if you recognize that there's serious issues when you cross from the plains into the Rockies. You've got major weather issues: downdrafts, updrafts, crosswinds. The elevation is radically different. It requires a lot of specialized knowledge. Well, when this major company bought out the Weather Service, they did it with the idea of making money. How do you make money? You consolidate services, so they only have 5 centers in the country. And one of them happened to be in Arizona, and which is fine. They said they had 1,000 people that were running this thing, when in fact they had 500. And then they had these people that they hired. Most of them were pilots themselves, and they ordered them not to tell people when they called, because they had a phone tree. We all know what phone trees do. You call here and it shifts you over here. Pilots didn't know where they were calling. So you might have a pilot from Virginia flying up to Maine that would call in, and the phone system would transfer them to a flight service specialist in Arizona. And the company wanted the flight service specialist in Arizona to give them weather advice. And to his credit, and to the credit of many of the people worked there, because I interviewed quite a few of them.
What company was that?
This was our favorite defense contractor, Lockheed Martin. This is an extremely powerful company. And to his credit, this whistleblower refused to do that repeatedly and openly.
He was worried about people getting killed.
Absolutely.
I mean,
he was a pilot, and he knew. And what he would do, the irony is, he was simply telling the pilots, I'm not in your area. You might want to talk to somebody in your area to get this information. And for Lockheed Martin, the contract was driven by time. Well, that might take time because, they're supposed to respond within 30 seconds and meet these protocols. And then they get bonuses. Mm-hmm. The managers get bonuses. So what was driving it was the profitability of the process, not the health and safety of the pilots and other people.
You should take your... Okay.
So obviously, a lot of the flight service specialists, because they were pilots, knew how dangerous it was. But what they did that this guy didn't do is they did it secretly. Before they would transfer somebody and say you have to go to another center, because I don't know, what your specifics of your weather.
So they would work around what the company
Yes.
wanted. They would, to avoid having a confrontation with Lockheed
It was
Martin.
an extremely chilled
around,
workplace.
Yeah, that's right.
And they all knew.
So they were all afraid and terrified.
Absolutely.
That if they actually...
They'd lose their job. Which
that,
this guy did.
And people do lose their jobs.
Yes. Reporting health and safety is a problem if we don't protect them. And that's the problem with this program. If we don't protect them, if we allow this kind of a chilled workplace to continue, we're not going to get the reports. We're not going to find out this is happening. We're not going to be able to protect an innocent pilot who comes and dials up, to get weather information, and he gets it from somebody in Arizona, and he's flying, in the dead of winter into Maine. You can imagine he's not going to get the quality of information that he or she needs to make the judgments about their flight.
And this is, you're saying, the direct result of privatization?
Yes.
How so?
Well, because the Weather Service would never do that. First of all, they would provide the pilots appropriate information in the appropriate region. And when Lockheed Martin took it over, they consolidated all of that into regional centers, you see. But instead of while there were boundaries or primary service areas, what they were doing was, because they didn't want to have a complement of service providers, they used this phone tree because it's more efficient, We don't have anybody sitting there for 5 minutes without anything to do. We'll have them answer this call from Florida. Without regard to the safety issues involved.
So what happened to this whistleblower?
Well, he was fired. He was treated very poorly for about a year and a half, and they fired him specifically for refusing to follow this protocol, which, by the way, at the time he was doing it, was prohibited by FAA regulation. Right, and that's you have a right, every right, to report violations of law and regulation, not just because you might see it as being something that's immediately dangerous, but the reason we have these regulations and laws is because other people have looked at these situations and said, to give the best protection, we need to have protocols that follow these rules and regulations. So they may know a lot more than you do. So it's always good practice to say, well, if there's a regulation to say, we do this, then we do this.
And this is a life and death question.
Absolutely. Absolutely.
I mean, people could get killed, planes could crash.
There are some suggestions. I think if somebody went back and did some studies of crashes during this period when Lockheed Martin has been in charge of providing weather information, any plane that went down due to weather, I think you need to ask, where were they getting their information from?
That's one of the unanswered questions.
Nobody's asking that in the federal government.
And in Congress?
No.
Why wouldn't they investigate the potential causes of accidents?
That's the not the FAA. That's the investigative branch that does air traffic accidents. They don't do it. Partly to
National Aeronautics and Space.
No, it's the
National Transportation
Safety Board, right?
NTSB.
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 Right, and they're the ones who investigate. Well, the reality is, an investigation after a crash takes years. So by the time that they finish their investigation and issue their report, it's probably at least 18 months, maybe 2-3 years down the road. And by that time, it's no longer hot news. Instead of the story being front page, you look on page 37 underneath the ad and you find a little, 3-inch story saying, oh, by the way, the NTSB said about these cases. It's also, there's a lot of assumptions, and that's one of the nuanced parts of being an investigator. A lot relies on your own experience and your own standards. If you're somebody like I am, I'm very detail oriented. I want to know not just what the law says. I want to understand the circumstances in which this occurred. So I will go and study the background, the backstory, and figure it out. But if you're with the NTSB, you may not have, again, the funding of these bodies, the leadership of these bodies. How much time do they devote to this stuff? How much is their report massaged through the bureaucracy before it's released? I mean, what's happening in my agency is the investigations are being rewritten by management to give a different color, a different twist, so that they can justify dismissing cases.
Now, there are also, you experience some maintenance problems with maintenance of jets and
Well, this is yeah. Well, we have a number of these guys, and interestingly enough, most of them came from one area in Los Angeles where they were all very experienced aircraft maintenance mechanics, and what they were discovering was cracks in the planes. Maintenance not being done, planes being left at LAX. I don't know if you know where the airport is. It's like a mile from the ocean. They were just letting them sit outside and weather, and that's a problem.
what company was that?
This is FedEx, and they were letting them sit outside and weather, which again, it's a lack of interest and concern about public safety. FedEx doesn't fly commercial flights for the passenger flying public. Yeah, but it does fly. It has the largest fleet of airplanes in the world, and they fly all the time. They're flying package express stuff. Well, the pattern is for FedEx, they buy old planes. They're cheap. Well, when you buy an old car, what are you buying? Maintenance. A lot of maintenance. And it's expensive. It's not cheap with an airplane. So, again, the business model and the drive for profit often leads companies like this to cut corners on health and safety. If the wing hasn't fallen off yet, it's not a problem. They've had fatal accidents involving these planes on the ground sometimes. But again, they're flying just like any other jet. They take off from LAX, they take off from SFO, from Oakland, all these, wherever they take off, they're flying over very heavily populated areas. If that wing falls off after takeoff, they could end up in your neighborhood.
So a mechanic had concerns about this, or how
Oh,
did you?
5 mechanics, the same facility. And they were all pretty legitimate. I'm not an aircraft maintenance guy, but you can start getting the picture when you get the reports. Some of them were fired, some of them were disciplined, but in reality, all of them reported consistently. FedEx maintains a very chilled workplace, very chilled. And this one guy was caught talking to an FAA official, and that led to the discipline. He's talking to the regulators. You can't have that.
Is that legal?
Oh no! I mean, this is what we protect. This is supposedly protected activity. I don't care if he was just giving them the time of day. If there's a perception that if they feel that they're at risk because this guy is talking to an FAA official, then there's a problem. And really, it's the intent of the statutes that's very important. They're supposed to be protecting whistleblowers, but not just protecting individual whistleblowers. They're supposed to be protecting a system that is accountable for health and safety issues. So if you don't protect the whistleblowers and you let a chilled workplace exist, it will grow up. No doubt about it. Anybody who's worked on a job knows if you watch somebody fired or disciplined for making a report, you're very unlikely to follow in their footsteps. And that's the big problem here.
So what happened at FedEx with the 5?
Well, it's still going on.
It's still going on.
And that's kind of a fiasco too, because there were so many people reporting. They report to the FAA. Violations of FAA regulations go to the FAA. If they then suffer retaliation, they come to us. We're supposed to be working with the FAA. This is true with the NRC, with all these other agencies. And there are good people and bad people in every agency. Some agencies have more good people, and some agencies have more bad people. But during the course of this, and when there were so many of these mechanics coming forward and saying there's serious problems with the maintenance of these aircraft, you have 5 senior mechanics come from one facility, there must be a problem. So they all reported to the FAA, and the FAA is supposed to come out and investigate. Well, the FAA, as I was told, well, we just don't have the experienced people to send out there to investigate. What? There. Then I was told because it was a big situation and it kind of boiled over, they were going to gather the team of 15, 16 of their best investigators and send them out and look at it. Well, I think four of them actually showed up, and they were there for a couple of days and left. It's just a failure to do the job.
And FedEx has a lot of money, a lot of
Oh
resources,
my, yes.
politicians, and
Oh my, yes. And they have a reputation for corrupting other agencies and doing these things. They're pretty much, in my mind, a rogue company, but they're a powerful company and they have lots of money.
now, is there any difference between a union,
No, not for
United
us.
Parcel Service? I mean, as far as the workers' fear of
Yes.
being retaliated against?
Absolutely. I mean, we do a lot of trucker cases, and I've done, I don't know, maybe 20 investigations involving truckers. Uh, and what I have found is, you know, that's Teamsters work. And where there's a union, there is not a chilled workplace, at least with Teamsters. The Teamsters Union is very good at advocating for its members. And when I've had a couple of cases that came up that involved union shops, it was amazing the difference in talking to management. They were respectful of their workers. They were respectful of me. I even got invited in to discuss the issues and to talk to some of the senior managers in this one area about health and safety issues. And they agreed to settle the matter and and it was the way things should work, really. And I found the managers in that company were, for the most part, quite receptive to understanding why they had a problem. I could sit down and point out to them the why these regulations were in place and how they could. It was probably what OSHA would have thought itself doing in any case. The difference was there was a union there, and with the companies that I've had that were non-union, they're real cowboys. And the standard practice for a lot of these companies now is to go out of business if they have a problem, and then they reopen as another name. And I've had drivers, very experienced drivers, who used to drive for Swift and some of the bigger companies, England, Swift, and they told me, they said, since 2000, the health and safety on all the companies has gone downhill.
And is that because of deregulation?
Yes.
And how has deregulation affected health and safety and
Well,
the public? And
it has
workers?
devalued health and safety. Health and safety is a cost. And if you're, in a environment where everybody is being subject to the same rules at the same level, you can invest in health and safety, and it doesn't hurt you competitively. But when you turn loose a lot of these companies, there's just lots and lots of little trunking companies now that have come in, and they'll stay in business for a year or two, or sometimes even less. They'll get a dozen trucks or something by them and put them on the road, and what they're doing is they're lowballing bids. And if you have a business that you can shift from one company to another, and the driving force for your business is profit, and you have a choice between a union shop that has good health and safety practices, but it might cost you 15-20% more, or some fly-by-night company, unless you absolutely know that they're going to wreck the truck and wreck your delivery, and they're going to charge you 20% less. That's goes to the bottom line.
You think that was the purpose of deregulation?
Absolutely. I mean, I think they've said this up front, that they want to impose a system which is driven by cost, not by health and safety. So it's the marketplace, the marketplace being the magic bullet, apparently, according to these guys, that resolves all these issues. But in reality, the DOT itself, the Department of Transportation itself, just recently reported there's been a huge spike in fatal truck accidents. I think it's 30% in 5 years. Why? Over hours driving, because the non-union truck companies push their drivers to drive and drive and drive. I've had cases where drivers have been fired for refusing to drive over hours. Well, they should, because they'll lose their commercial license. Poor maintenance. I remember years ago we used to be concerned about these, the Reno Express buses that would take senior citizens up to Reno, and we find out how well are the drivers allowed to manage their driving in the best circumstances and not being forced to drive over hours. The FedEx, it was a FedEx truck. The FedEx truck that head on to that school bus last year going up to Eureka. Indications are that this driver was driving over hours, crossed the median, hit that bus head on. He probably never knew what happened.
And you're saying that that's a direct result of the fact that they're driving down costs and they're intimidating the workers.
Absolutely.
So the workers are really afraid to even enforce the laws that are on the books for the protection of the public and workers.
Absolutely. And, trucking is a very competitive, if you're a driver, it's very competitive. A lot of these guys, they're not making much money. There's been a lot of changes where drivers are now required to have their own truck, the cabs, do the maintenance, pay the fuel. And so, in effect, a lot of the drivers have lost maybe a third or more of their income over the last 10, 12 years because of this new system that's been imposed on commercial trucking. So they're suffering. If you try to organize a union, I think, the problem is these companies, particularly the small ones that have maybe 10, 15 drivers, maybe 15, 20 trucks, they're non-union shops. They go out there and if they run into problems, they have a major accident, the way that the law is constructed, they can simply go out of business, declare bankruptcy, disappear, and show up at a town and a city in the next state with all the residuals of their trucks and open business again and do it all over again. The fourth case was this one involving the railroad. And what happened was the area director did ask questions about the cases because it was obvious that when you're talking about falsifying government documents, that's a very serious charge. He would not tell me, which was what he should have done, he wouldn't tell me that I should go to the Office of Special Counsel, which is where it should have been investigated. He also would not bring anyone in from the outside to look at the charges. He conducted a very superficial investigation on his own. What he did, just like the FRA, he asked Mr. Paul and his supervisor what happened, and they lied to him. And that was all right because then he didn't have to do any more work. So
you have federal officials, even lawyers, who are actually falsifying federal documents, who are manipulating the information, the facts on this case, and you have sent letters
to everybody.
To everybody and to senators.
To senators. Well, that was my first one. It was in June of 2012. Those 4 cases, to the area director and to the national office. After that, I was subjected to a very intense and hostile disciplinary hearing for sharing information with complainants, which I'm required to do by law. Nevertheless, they didn't like that because sharing information with people is one way of bringing to light what's happening. And in addition to being required by the manual to share information with complainants, they have a right. They have a fundamental due process right to see the product of the investigation that they have asked for. The agency hates to do that. In fact, this is a policy in the agency, high-level policy, not to share information with people, to conceal. So I brought that issue up, and I sent that to the area director, and I sent that up the line again to the national office, And I ended up, later I found out it went all the way to the top of OSHA, which is a Deputy Assistant Secretary of Labor.
Who is that?
That at the time was Richard Fairfax. He retired after that. But that's the person just below the Secretary of Labor, works with OSHA. And what I saw was the area director telling them, oh, we're working on discipline for this guy. Because I raised the issue about concealing information from people, depriving people of their due process rights. And I specifically said, I think it's being done because the agency is trying to protect wrongdoing.
Now, these whistleblowers that you know and have worked with over your time in OSHA, are many of them are very conscientious. Many of them really want to protect themselves and protect the public. And yet it seems like they're being not only disenfranchised of their rights to be whistleblowers, but also their lives are being
destroyed in some cases. I mean, my experience, and I've had conversations with some good people in the program about about this very thing. Who is a whistleblower? And we all agree 90% of the people who come to us are genuine whistleblowers. It's rare for somebody to manufacture something that comes to us. We get them occasionally. The problem then becomes actually qualifying them under the law as a whistleblower. It's hard because we have to often get information from companies that are reluctant, not likely to give it to us, or the complaining party has to have the information, or we have to talk to employees who are willing to talk to us. It's very difficult. But about 1 in 3 cases are whistleblowers that qualify. The 90% of people who come to us never envision themselves as a whistleblower. If you had, in fact, when I oftentimes first talk to them, they're very uncomfortable with being called a whistleblower. To them, like Mr. Madry and these other folks, they're simply doing their job. There's a health or safety issue that they're concerned about, they report it to somebody. What we'd like to think that most times when somebody does that they're taken seriously, they look at the situation and try to take corrective action. Unfortunately, there are many times when taking corrective action costs money. And a lot of companies are squeezing everything that they can to get as much profit as they can, and health and safety don't generate profits. They generate costs. So when someone comes and reports something, they see it as a cost. And if these people do it too often, then they see them as a threat to their profitability. And a lot of companies believe that employment is at will. It's called at will in California. And with the idea that, well, we can fire you for any reason, any time. So if you come to us with a problem like that, we'll just fire you. And employees don't realize, most of them don't realize, that there are protections for reporting health and safety issues. And there are protections for employees in a lot of different areas for doing that. They don't know that. They're not well educated about it. So they simply accept, well, the company fired me, gee, I shouldn't have opened my mouth. So the next thing that happens is every other employee in that company, oh, John got fired for, reporting the leaky gas main. Well, let's not report anything. That's what happens. That leads to really bad outcomes. In my agency, with the senior officials, what they think about is this is a powerful corporation, business interests, and we don't want to get crosswise with them because they'll make us trouble.
And have you seen any direct influence of these corporations on your department?
Well, it's interesting you bring that up. There was a statute passed in 2000, Air 21. The Wendell H. Ford Aviation Investment program for the 21st century. Anyway, it's kind of a long title, but that bill was passed as a consequence, at least in part as a consequence, of an air crash in 2000 involving Alaskan Airlines, where 80 people died. And it's down here near Los Angeles. And what they discovered was The crash was caused by a worm screw in the tail assembly that was known to be defective by the mechanics, many of whom had reported it to the company, some of whom had been fired for reporting it to the company, that was known to the FAA. And they didn't do anything, and so the 80 people died. And in response, to its credit, Congress passed this bill, Air 21. And Air 21 was maybe the point where things should have changed with OSHA, because that was the bill that started the preliminary reinstatement with back pay and damages. If we find merit, we're supposed to issue that order. It goes out. It's effective immediately on receipt. That's a very powerful weapon. What happened as soon as that bill came out, the airline industry screamed bloody murder. Because this was going to be a big gun pointed at their head to say, you better respect aircraft, air safety, and when they come with reports, you better respect them and do something, because if they end up as whistleblowers, we're going to do this. They raised holy hell about that. Hearings, this, pressure here, pressure that. Well, as a consequence, OSHA itself, not the Congress, but OSHA, evolved a whole new rule. Well, before we issue the order, we'll issue you a letter, a due process letter. And in this due process letter, we'll tell you the outcome of our investigation, and we'll invite you to come and give us more information or ask us to do more interviews. Basically to drag out the investigation further.
And to give them a break.
On
health and safety protection of whistleblowers.
Basically, because what's now happened is when they do that, of course, the company attorneys, like happened in the other case with Lockheed Martin, they call up and then they pressure, manipulate, cajole, bribe, I don't know, but they get the supervisors to dismiss the case. It's sort of like, okay, before we have to actually confront the jury's decision on this, we will have an opportunity to change the outcome. And interestingly enough, Mr. Paul himself, back when this new rule came in about 2004, he argued against it. He argued against it, and not for the companies. He didn't want to send it to the complainant, to tell the complainant that there had been a merit finding in his case or her case.
He wanted to keep that a secret.
He wanted to keep it a secret. He did not want. It's all right to give it to the company and give the company a chance to come in and get
Who
a second.
Who is this Mr. Paul?
That's a good question. The company can come in and get a second bite of the apple, in effect. Can delay the outcome, can manipulate the process, but we're not even going to tell the complainant that they're doing that. And he argued, fortunately, there were people in the national office who said, no, due process, the Constitution of the United States requires us to share the information with the complainant.
So how many letters are there like this since that law was passed?
The letters are very common. When there's a merit finding with these Air 21 or any statute that has a preliminary reinstatement clause, the agency will send out a due process letter anytime the investigation shows merit. And it's at that point that most of the merit investigations are rewritten, you see, because nothing is final at that point. The due process letter is just a letter of advising the parties. It's not in the official position of the department.
So it's a way of allowing administrative opportunity.
Yes.
For the companies to stall and pressurize and get away from doing what they should be doing as far as complying with the law.
And even under the way it was originally drafted in 2004 or so in there by OSHA, this due process letter was supposed to give them 10 days, a fairly narrow amount of time. If there's something, and they were only supposed to be able to submit relevant documents, relevant ask for relevant witnesses. And actually, relevancy is supposed to be what the investigator determines to be relevant. So if I have a case which involves, like the aircraft maintenance thing, if they say, well, you didn't talk to the to this supervisor who did the safety checks, it might be a relevant interview. Or there are documents showing that this guy actually was causing the cracks with his work. That's relevant information. I should have that, and I should consider it in an investigation. But what they want to do is, oh, we want you to talk to our senior vice president about what our philosophy is, or here's something that came out, from some place that's 2 or 3 months after we fired this guy. It said X or Y. That's not relevant.
So could they change this? Could Secretary Perez change this administrative procedure?
Probably not.
It's in the law?
No, it's not in the law. It's in OSHA, but it's a rule-making process. Federal rulemaking is kind of convoluted in its sense itself. It has to go through kind of hearing stages. Definitely that due process letter. The big problem with the whole thing is we have laws, we have regulations, we have rules, we have a manual. Nobody is enforcing what's already there. Nobody is saying 10 days is 10 days is 10 days. We shouldn't be sending this out and saying, oh, well, we're not serious about that. We'll call us next month or a couple of months from now. That's what they do. That's true with all of this stuff. We have adequate laws. The rules are fine. The regulations are good. The administration is not taking note of any of it and not observing it.
So they're not enforcing it.
Correct.
Did you have any experience with biotech and health and safety in laboratories?
Only remotely. I didn't have a lot of cases. Interestingly enough, the case involving nuclear power, it's nuclear materials, period. So I've had a couple of cases involving nuclear medicine and the protection and use of nuclear materials in medicine. And those have been quite interesting. One was with one of the UC hospitals, and with a pretty high level doctor who was concerned about the way that they were handling the materials in his program. But no, I haven't. Otherwise,
because the biotech industry is
right. Potentially, it's covered. It should be covered under what's called the TSCA, which is a Toxic Substance Control Act. Again, you get into an area, and this is where, unfortunately, there's a lot of manipulation. How things are defined. Is a particular biotechnology substance defined as a toxic material? Is it defined in some way that gives regulatory authority to someone in the government to manage it? That's a critical point. Because if you can't, it's all based on legal definitions, and if you can't get it inside the corral, you can't deal with it.
And these companies, of course, don't want regulation.
They also have hundreds of attorneys, They spend a lot of money on attorneys, trying to protect themselves. I've heard, rumor has it, that FedEx has one of the largest in-house legal organizations in the country, like 400 lawyers. But
that's a lot of lawyers.
It's a lot of lawyers, yeah. And when you have, think about it. You've got these companies with these very large, very powerful legal departments. They have unlimited resources in their legal departments. And they're pitted against OSHA, who has to rely on the solicitor of labor. They have to take 3-hour lunches. They're considered incompetent. They don't like to go into court over a drug issue in an argument. What's the chances? You're taking children into a professional boxing ring. It's not a level playing field.